I want them to step outside. There are two gentlemen in the back. I don't know who they are. You related to this matter?
Yeah.
No, if you're not going to be a witness, then don't step out. You're fine. You don't have to identify yourself. All right, very good. Okay, go ahead. I'm listening, Mr. Sheriff. Thank you, sir. I'm sorry about interrupting you. I just didn't want any improprieties. Go ahead.
Right, and I think it was appropriate for you to say that at this time. Except that, you know, usually on issues before the court, you have one party for each side. And last time I was getting double teamed. Although I can take it, it's procedurally you have one person arguing for the prosecution on this, and we don't need double teaming 3 or 4 people who are on the prosecution team. So can we have one person designated who's going to be making the arguments and doing the hearing today?
You know, I'm going to just say this to you. You know, this case, you know, everybody's been telling me from the prosecution to the defense that this is a very unique and complex case. I agree with you. I have never seen multiple pleadings from the initial pleading was from Mr. Hinderline. Then I get a memorandum of law authored by Pat Muscat that was hand delivered to my court on February 14th at 3 o'clock in the afternoon. He's not here.
Yeah.
So basically, who's going to argue this? Mr. Hinderline, are you going to do it? Or Mr. Moran?
I'm prepared to argue the memorandum that was prepared by Mr. Muscat.
Okay, very good.
Okay. And several procedural things. First of all, I also got this memorandum late on Friday. I was not aware that a transcript had been ordered, although I see snippets of that in the file, and I had no notice that in fact the transcript had been ordered, and I didn't have a chance to obtain a copy because the courts were closed yesterday. More importantly, though, is I've made numerous requests for a copy of the affidavit from the search warrant at my client's home, and the response has been continuously that it's under seal. Well, that's another unusual circumstance. We're talking about a case that's so old it was supposed to go to trial within the next month, and there's a sealed affidavit, and based upon the statute, an affidavit is supposed to be sealed for 56 days, and after that period of time, that the prosecutor's office can seal it for additional time. I never got a copy of anything that it was sealed, and in fact, I'm prepared to argue today, but I think that I wonder why my requests to have it unsealed have gone ignored, and in fact why it still has to be sealed if in fact we're talking, you know, that's at the core of the issues here is the search warrant affidavit.
Let me understand this, and I'm going to get back to that momentarily. When was this affidavit sealed?
Oh, Your Honor, the affidavit was sealed at the time the warrant was presented to the circuit judge to review the search warrant.
And that date was?
That date was in October. I have it in front of me. October 20-something, Your Honor, of last year.
No, of 2012.
That's last year, 2012. This is no 2013.
2013.
Yes.
All right, go ahead. I'm listening. For the memorandum, go ahead. Sure. I'm going to deal with this memorandum, and I'm going to deal with those issues.
If I may address Mr. Sharp's issues first, because he talked about a couple of things that need to be addressed prior to going to the memorandum. That's okay with the court.
That's fine.
He first indicates that we're double and triple teaming him, but the unfortunate reality is, Your Honor, is that given the shortness in our staff, we are spread thin. I've been in trial for last month. Mr. Hinderling was here. He was in trial with me, and he was also here at times. Ms. Lindsay has other matters to be here on, and the unfortunate reality is that, yeah, it would be nice if just one person or two people could handle this case, but because we have other obligations in this office, that's just not physically possible at this time to do so. As it relates to the memorandum of law that was presented to the court last week, this is really a sum and substance of an email that was sent out probably a month ago by Mr. Hinderling, which laid out the law and the facts, and it's just a summary of that, plugging in the transcript references from the last 2 court proceedings that we had. So Mr. Sharp had that in his email at least 3 weeks ago. So he's not really in a position to claim surprise by the memorandum. We just wanted to put our position clearly on the record.
And this is what is so unique and is difficult. That's not what the courtroom requires. all of this emailing back to various parties, at some point in time, that's just not acceptable. Mr. Sharg has indicated, and the court rules require that there be personal service if there is going to be motions that are going to be made. But this atmosphere of emailing, and then Mr. Sharg says, well, you know what, I don't have notice of what's going on. That's what happens when it's not properly done.
I agree with the court, and part of the problem that we have, Your Honor, is that we're at a loss because we didn't ask for this hearing, and we didn't file a motion in this case. The court on its own set this hearing sua sponte.
Right. And this is what, I saw the two cases that were presented and cited, and the court wants to talk about MCR 6.201 when it talks about disclosure of privileged information. MCR 6.201(2)C says, regardless of whether the court determines that the record should be made available to defense, the court shall make findings sufficient to facilitate a meaningful appellate review. Now, what we have here are incidences that have not gone recorded. There has been a presentation of a search warrant to a circuit court judge while this case was pending before me, which you deal with in a memorandum as investigation. Then there is an appointment by a trial court judge to a master without the trial court that's presiding over it, without my permission or knowledge. There is no order in that file that judge ordered the master to even prepare a report. So how would there be an opportunity to make a finding sufficient to facilitate meaning appellate review when there are no orders, when there is no record? And please, if there's transcripts of the proceedings that you went before Judge Hathaway, I didn't get them.
Judge, I think the court is talking about Michigan Court Rule 6.201, and that's the discovery aspect of once a criminal case is filed. When we have a discovery, a criminal case pending.
But it deals with privileged information being turned over, and that's my understanding, that we have to make a determination as to the information and whether or not there's an attorney-client privilege in regard to what was seized by the search warrant.
Yeah, but we're way ahead of ourselves, Judge, when we're talking about 6.201, because we're not even at that point. Mr. Valente and Mr. Shark have not been charged with anything criminally. There's no criminal case pending. That rule does not apply. That may apply to Mr. Bashara if at some point in the future any of this evidence that was seized we seek to introduce. But we're not even at that point yet, Your Honor. So we're not even at the point of making a record that relates to I think it was, what was it?
But my understanding, 6.201C, but my understanding is that the evidence that was taken, that the reason that the master reviewed it is there was a determination that she wants to turn it over to the prosecutor's office so you can use it in your case in chief? I
don't know. I have not seen the master's report. The reason the master was appointed, Your Honor, is because the unusual nature of the search warrant. When we do a search warrant on an attorney's office to seize materials that may be part of a criminal investigation, we were seeking to protect not only the defendant's rights but also the rights of the attorney by not having that information tabulated, by not having it reviewed by the police officers, by having it sealed, having it preserved, and then agreeing to the procedure of having a master appointed to evaluate the evidence to see if there's anything there that's remotely relevant to our criminal case. So those efforts were agreed to by us to protect not only Mr.
Agreed to by whom?
By the
Between
people,
yourselves?
the people of the state of Michigan and Mr. Sharg representing Mr. Valente.
Mr. Sharg is shaking his head.
I'll respond because that's not totally accurate.
But go ahead.
Well,
see, that's where we are. And this is what's frustrating to me. Because we're not dealing in orders, we're at a position where Mr. Sharg says, no, I didn't say that. And there may have been an understanding. Per my review of some of the emails, Mr. Sharg was a willing participant.
Correct.
But I can't then incorporate that to anything because it was not taken in a courtroom. It was just what I believe it to be. And that's my problem with how everything is going. I want everything now to be, unfortunately, by testimony, by order, because I don't want someone to be able to come back later and say, well, that wasn't my understanding.
Well, just part of the problem that we're having is that the court doesn't really have jurisdiction over this issue. The court is the trial court, and the court has jurisdiction over trial issues of witnesses, issues of evidence, issues of motions. But when we're dealing with something that we're still investigating, the court...
Wait a minute, hold on for a minute. You're still investigating. We're 5,000 page documents into the investigation of Mr. Bashir. He's been charged.
Correct.
And you're still investigating.
That's our obligation, Your Honor. As prosecutors,
okay.
We have an obligation to continue the investigation even after someone is charged. We do that...
You do that when?
All the time. We do it in every case. If we have a murder case and the defendant comes forward and says, I have alibi witnesses, we have an obligation to go out and look at them. DNA evidence comes in, we have an obligation not to ignore it, but to continue the investigation. And sometimes during the course of a case, even after an arraignment, there are search warrants. There are other issues that have to be examined, and my point is that that's investigative. That's an investigation. That's nothing
your
to do.
determination.
Correct. That's
and
our
here's
problem.
The situation. These search warrants predated, as I understand, the charging of Mr. Bashir.
Some search warrants predated and some postdated.
As it related to Mr. Valente, is that correct?
I think the search warrants were in October of last year, Your Honor. That was after.
No, that's why we don't have it. Do you have a search warrant?
Do I have the search warrant? Not on me, but I can get I can get the search warrant. I can get a copy of the search warrant. It was in October, I'm told, of 2013.
Okay. And so, but the request from the information that was contained in the search warrant came back in March and May. Is that correct? There was some information on a cell phone. I mean, not on a cell phone, but on a jail phone.
Right.
That occurred back in March or May of 2013. That was the basis of the search warrant being executed in October. Is that my understanding?
That was part of the basis, Your Honor. To be accurate, that was only part of the basis. There
okay,
was
now
additional
Mr. Bashara got charged in
April, I think, of 2013,
okay.
And then.
So we know at least some of this is in regards to Mr. Valente predated that. Is that correct?
Yes.
Okay. And then this information, some 5 or 6 months old. Can you tell me how it was that you took that information and you waited that long to get a search warrant?
I can tell you that based on all the investigation that we were doing at that time, we had an affidavit that was prepared by the affiant presented to the circuit judge, and the circuit judge found probable cause. And in that affidavit, which I believe is 10 or 11 pages long.
And I'm just kind of curious, is there not a requirement that circuit judge that you arbitrarily went to make an order appointing that master? Or
Judge, first of all, I take an issue with the court's determination of arbitrary. We went to the presiding judge of the criminal division and were directed to go by the presiding judge to Judge Hathaway as his alternate. So it wasn't arbitrary on our part. We followed the same procedure that we followed in every other search warrant, in this case, taking it to the presiding judge. And the presiding judge is the one who directed us to go to Michael Hathaway.
Oh, okay. And that was despite the case being assigned to me.
That's correct, because there's no court rule, there's no law, there's no statute, there's no constitutional provision that says that post-AOI search warrants have to go to the trial court. In fact, according to the case that we found, there's strong evidence to suggest the opposite, that it's a good reason not to take search warrants to the judge who's assigned to the trial, because the judge would be reviewing evidence that may not be admitted at trial. And then two problems. One, they might then have to rule on evidence, suppression of evidence that they authorize to be seized. And two, if they make a determination in trial, they may be making determinations based on facts that are not in evidence. And so the better practice is not for trial judges to sit and review search warrants on investigations that continue after the arraignment.
Well, what was interesting is that in your brief, the Genesee prosecutor versus Genesee Circuit Court judge, that particular case was after the arraignment. That was a charge that was made, and the judge decided arbitrarily to take a plea to a lesser charge. But what's interesting, and the court had an opportunity to look at, was the Figer versus Cox case, in which it talked about the people, the Attorney General, going and getting search warrants from a district court judge, and how the plaintiff in that manner, Mr. Figer, then arbitrarily went to a circuit court judge under the guise of asking for superintendent control to get the district court judge to stay any further action of the district court and to preclude any further search warrants. And the Court of Appeals said that that type of action on behalf of them, instead the circuit court exceeded its authority and then improperly rewarded plaintiffs forum shopping, first by wrongfully taking the case, and secondly by improperly interfering with the legitimate and proper investigation by the Attorney General. I'm not saying that you don't have a right to do further investigation. That would be preposterous.
Right.
What I am saying, however, that I do believe that it would have been appropriate for this court to know that this matter was taken to another judge as part of this investigation when the case was assigned to me.
Judge, I understand the court's concern, but there simply is no law, there's no rule, there's no precedent, there's nothing that says that the trial court has to be notified that we continue to investigate a case.
Moreover, let me just say this, and in that case it says that basically that what the plaintiff did, although there was no law on point, like what you say, the participation of a circuit court judge to thwart a legitimate felony investigation through technical gamemanship involving our judicial system. So basically it's this. Well, it's not a statute that requires you to know. So therefore we opted to not do that because we wanted to protect you. However, it's so ironic because there were witness detainers that were brought to me on this matter.
Yes, Judge, but a witness detainer is different than a search warrant. And just to follow up on the point.
I'm just saying, why wasn't I given the information that another circuit court judge was signing search warrant and appointing masters to determine the admissibility or the legality of information that was seized from Mr. Valenti's house?
Can I ask the court a question? How would I do that? How would I notify them?
First of all, I think that it would have been incumbent upon the people to have come before this court and let me make the determination, first of all, that for the reasons that you've stated, that it may be improper for me to sign the search warrant and then to seek some type of assistance either from the circuit presiding court or from my alternate, which is normally done. That's normally done because that's why we have alternates.
Okay.
Then I think what would have been appropriate is after that judge signed that search warrant, that I then had been requested to have a interview with the prosecution as well as the defense to then appoint a master that I believed would be capable to go through that information and then give me the report so that I could review it in camera to make a determination of its admissibility. That's what I think the procedure should have been.
So, Judge, what you're saying to us is that we should come to you and tell you ex parte that we're going to continue an investigation.
No, I
and
think
we should have ex parte communication.
Me.
Judge,
go ahead. I'm sorry.
Judge, we can't come to you. You are the trial judge,
okay,
and you represent the arbiter of the people versus the defendant. And if we're continuing our investigation and we want to have a search warrant, what you're saying is we should come to you and say, Judge, we want to do a search warrant on some property that we may admit against him, but we can't do that.
Listen, this is what I do. I'll agree. That I agree with you. But once that search warrant was executed and those documents were obtained, then it was your responsibility to say, now we got something, Judge, that we got another judge to do, and we need your help. We need your help to appoint a master to make a determination. The master is going to determine, A, is there a privilege? in this particular information.
So you're agreeing with us that we can't come to this trial judge
Possibly.
for search warrants because that would be ex parte.
Yeah, but that possibly.
And so that's
I'll
improper.
concede that.
Okay, so there's the procedure that was followed for the execution of the search warrant, all the things that we did. Previously, the court had said we were forum shopping. Previously, the court had accused us of going around this.
And you know what?
Judge, may I finish?
No. And let me just say this to you. I'm woman enough to retract it and say I was wrong.
Okay.
Okay. Now, I was wrong. I'll concede that. But now that the information, you've been to Mr. Valenti's house and you got all the stuff out, why wasn't I then informed, hey, we got some evidence and we need some help? Why wasn't I informed about that?
Again, Judge, because we don't know what that evidence is, and we're not there yet. We're not at the point of where this is even going to come in against Mr. Bashara. This is a court order signed by a co-equal judge. Judge Hathaway is a co-equal judge to this court. He signed the order. It's his jurisdiction on that case. He's the one who had the meeting with us, with the defense, with Mr. Shard. He's the one who appointed the master.
But why?
Because he's the one who signed the search warrant. He's the one who authorized the law enforcement to go execute that search warrant and seize the evidence.
If the search warrant were signed by him because you brought it to me, and I said, I think that it's in the best interest to have either my alternate or to have the presiding judge to sign the search warrant, then that portion would have been delegated to somebody else. But then the ultimate decision, once this information was retrieved and the master that should have been put on that case, the court believes should have been in my purview at that point because it was during the case was before me.
Again, Your Honor.
I disagree.
Okay, and I think your disagreement is properly levied to Judge Hathaway, not to us. Because Judge Hathaway is the one who appointed the master. Judge Hathaway is the one who had the meeting with us and said, I'm going to appoint a master to review the documents and then get a report and make a determination.
But wait a minute. First of all, isn't it the responsibility for the prosecution, the court, to be forthcoming so that the defense has an opportunity to address anything that has occurred? And see, that's what's going. This is gamemanship, and this is the part that I don't like about what happened in this particular case. Well, should the court really take that up with Judge Hathaway? No,
Judge,
I don't think so.
Okay, with all due respect,
Here's the situation. There is no record. There is no record. Is there a record of the search warrant?
Yes, there's an affidavit, there's a search warrant that's been authorized by the judge and signed.
When Mr. Shard was present, when there was discussion about the master being appointed, was there a record made?
I don't know. I was present.
Don't know?
I don't know if it was on the record. I'm not sure if notes were taken. I'm not sure. Judge, but here's the problem I have.
So how is there appropriate appellate review of Mr. Hathaway or Judge Hathaway's decision of what you said or what he said? There's no record. And so what happens is, and when there is no record, it falls upon each side to say what they believed occurred at that particular hearing.
Correct, but Judge, there's no basis for a record. There's no basis for judicial intervention at all. Because you're way ahead of, the court's way ahead of itself on this issue. Because there's no reason to have.
Well, let me ask this question. If there was not a need for judicial intervention, then why did Judge Hathaway appoint a master?
When I say judicial intervention, I mean the trial judge's intervention. Because there's no evidence yet that we're seeking to admit in this case. The case that's before you. We are not at this point ready to say we want to admit these 3 items, these 4 items, these 15 items that were taken pursuant to the search warrant against the defendant. So that's what this court's jurisdiction is. This court's jurisdiction is the people of the state of Michigan versus Mr. Bashara, not Mr. Valente. Mr. Valente's house was searched by a court order that was signed by a judge of co-equal jurisdiction. And the problem I have with this court is that, first of all, you accuse us of being unethical by saying that we're forum shopping. Second of all, you enter an order saying that we cannot get search warrants in this case without your authority. Then you say we can't issue subpoenas without your authority, without your approval. And now you're saying we're playing games when we agree to a procedure to protect this person's rights and have a meeting with a circuit judge where we agree to a master and agree the documents be sealed and not be examined by police officers, and the court says we're playing games?
But wait a minute. You don't have a record of that, do you?
Judge, there was a meeting with a circuit judge with
Mr.
7 or 8 lawyers.
Shard is shaking his head.
He was there, Judge. He was at the meeting.
That's right. I was.
Okay.
Can I get a chance?
And he agreed to the procedures that we followed, and everyone agreed, and then the master was appointed, and those proceedings were advancing.
But just like the court says in the Figer case, the proper thing to do is appeal. If you disagree, if you say, Judge, you don't have the right to say that we can't issue investigative subpoenas, appeal me. Don't go to another judge of co-equal jurisdiction.
Judge, we've never done that. We have never sought to overrule you. We've never gone around you. You accuse us of doing that time again, but we've never done that. We didn't come to you and you deny a search warrant or deny us an order, and then we go to a judge of co-equal jurisdiction and go around you. That would be improper. We've never done that.
No, I wasn't given the opportunity.
And nor are you required to be given the opportunity. There's no law, no court rule, no statute, no ordinance, nothing that requires us to bring a search warrant to the judge whose the case is assigned to. In fact, the evidence suggests that's not a good idea to do that.
Okay, and that case says?
There,
that says that the trial judge should not be presented with a search warrant?
There are a number of cases, Your Honor, that talk about how it's not a good idea for a trial judge. We referenced one, I believe, in our brief. There's other cases that are not from the state of Michigan.
I looked at the ones that were in your brief. The only ones that I got on this memorandum were Genesee Prosecutor versus Genesee Circuit Court, 386 Miss 672, Figer versus Cox, 274, Mishat 449.
Right.
That's all I got.
Okay.
Now, maybe I didn't get the other part.
And did any of those cases say that we're required to bring a search warrant to this court? No. Did any of those cite a court rule? No.
Well, first
a statute?
of all,
no.
They're factually distinguishable because the Figer case dealt with an investigation before the defendant was even charged.
Correct.
The Genesee County case dealt with a plea-taking procedure by which a judge took a plea to a lesser offense. So technically speaking, none of these cases are on point anyway, factually. They all have the same verbiage that it is in the purview of the executive branch as investigating as a prosecutor to be the sole investigator of the county. Basically, that's all it's stating. But these cases are not factually on point.
Judge, they are on point because they say that the court does not have jurisdiction over us.
Factually.
The law is clear that the circuit court does not have superintending control over the prosecutor. We have the right to investigate our case. The court cannot tell us how to do that, when to do that.
I agree with that.
And
once these formal charges were made against Bashara, in all fairness, the court believes that I should have been made aware of what was going on.
First of all,
that's it. I'm not going to hear anymore. I don't want to hear from you. Wait a minute. No, no.
May I finish the record? May I make a record at least?
Okay, go ahead. And then I want to hear from Mr. Sharp.
There's no rule or law that says that.
Okay.
I'm sorry if we offended you, but if we offended you, I apologize. But we can't do that because that would be ex parte communications, Judge. We can't come to you and say, we want to execute a search warrant on some property that may yield evidence against Mr. Bashara and tell you what that is without co-counsel being there because you are the trier of fact in this case.
Okay.
And so if we did that, that would be ex parte communication. That would be entirely improper.
Okay, very good. Mr. Sharp?
I can't believe what I'm hearing and how not only are they stepping over each other, but Mr. Moran, who I respect, is stepping over himself today for the simple reason is ex parte and that they don't want you to be tainted. The prosecutor gave you a copy of the search warrant affidavit to review. So if they didn't want you to get tainted by knowing anything about the search warrant, why did they give it to you in the first place? Last month. Their whole argument defies logic. In terms of this case, they're still investigating. Mr. Bashara was doing, I believe, maybe 15 years in prison on another case while they're investigating. There's no statute of limitations. They had free reign to investigate this case as long as they wanted to and complete, connect all the dots and do everything they needed to do before they charged him with this offense. He's sitting in prison for 15 years. There's no statute of limitations, and yet they're saying weeks before this, I guess, a scheduled trial in this matter, they're still investigating. It's mind-boggling that the Dream Team, and the last time I saw 4 lawyers on the same case was in the OJ case, why they need 4 lawyers to do a homicide case, when in federal court they're doing death penalty cases with 1 or 2 U.S. attorneys, I guess, who are experienced to handle things. but more importantly, ex parte, in federal court and in other circuit courts around this state, what the prosecution could have done, and they should have done, was file ex parte, under seal, a document to the court, at least advising the court of what's going on in this case, and at no point in time did they do so. The only time you found out about this case was that when I'm playing games with the prosecution and trying to get back my client's
No,
records.
you're wrong. Let me interrupt you.
I said it. No, I said it. Cece.
Excuse me. No, the first time I heard about it was at a dinner party from the master.
Okay.
But go ahead.
Well, before she was appointed, and we're circulating these emails and negotiations, and I said, why isn't Judge Evans involved in this conversation? And so there's the first email, as I emailed the others and said, why isn't Judge Evans participating in this? Why don't we have her involved? I had no idea what's going on in this case. I came in only, at a late point to get Mr. Valente's records back. I don't know, they're the ones that, the prosecution are the ones that should be held accountable because they know exactly what they were doing in this case. They know when they were seeking judges to sign affidavits, they knew all these things. And I come in because my client's home office is raided. We're trying to get back his files, and then I hear for the first time that they haven't done an inventory, which at the house. They just sealed everything and took it down to the prosecutor's office. So there's a conversation that it's Judge Hathaway signed the affidavit. I didn't know the history of this case, so we agreed to go to Judge Hathaway because I don't know anything. And then all of a sudden, it's Judge Hathaway that appoints the master. And again, as my understanding was they even excluded Mr. Bashara's lawyers from Judge Hathaway excluded Bashara's lawyers from any of this conversation. So they weren't even able to review the documents which were possible work product or privilege or whatever. The bottom line is that this is just a big mess. As the court said, this is the first time I heard about Judge Kenney recusing himself was in the response the other day in this memo that Mr. Muscat. I had no idea what was going on until that point. The problem is, as the court said, this is just just going back to the core, and I'll sit down. We're talking about the prosecutor's office obtaining a subpoena and a search warrant, one in the left hand, one in the right hand, and going into an attorney's house office and raiding that office, and which is done rarely, and it has to be done with very conscious and cognizant understanding of what we're dealing with.
Well, here, look, I'm going to say this to you. We've done enough. We've been over this road enough, okay? And we've made a record. Good, bad, and different, we made a record. What I do want to do, I understand your position, both of your positions are noted, okay? And at this point, I don't want to make it appear that I am accusing the prosecutor's office of anything. I know the prosecutor's office is working very, very hard in this case as well as other cases under a handicap because there's not enough people that are in this office to do the type of job that I believe that the leadership of Kim Worthy would want to see, okay? Number one. So I understand with Mr. Valente, we're here today to get to the bottom of all of this. There's going to be a record made. That record can be reviewed, and whatever happens in this case, learned or graded minds, make a decision. But what I want to do today is I want to be able to make a record as to what occurred as far as there was I think that, I'm not going over the search warrant, but I believe that there was one that was signed. I just need to know the testimony of what was taken. Then there was a master who was appointed, so that after there is a record that is made, then I can make a determination as to what the proper orders are to be to go forward from here. In that there needs to be a proper order done, preserving this evidence as well as ordering the master to review it in a timely fashion, and giving this court an opportunity, if there is evidence that is not privileged to, or is not work product, I'm sorry, to make an in-camera inspection. So that's what we're here to do today. I don't want to hear any more argument. Your positions are known. Okay. Can attorneys approach? Not on Mr. Bashara. Back on record. Okay, where's Mr. White? Is he present?
I believe he's sequestered. I'll get him.
All right, sir, raise your right hand. Do you solemnly swear affirm testimony about to give this man as the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do, ma'am.
You may sit. State your name for the record.
Brian White.
Pull a microphone up. Okay.
Brian White.
Brian White.
Okay.
I got you.
Brian White, you're a detective with the Wayne County Prosecutor's Office, is that correct?
Yes, I am.
In fact, you're the Deputy Chief of the Wayne County Investigative Bureau, is that right?
Yes, I am.
How long have you been a detective?
12 years.
And back in October of this year, did you...
October 29, 2013.
Of 2013, did you prepare an affidavit for some evidence to be seized from Dean Valente?
Yes, I did.
And with every affidavit that you prepare, is that pursuant to the request for a search warrant?
Yes, I did.
And in order to get a search warrant signed, you know you have to take it to a circuit judge or a district court judge, is that right?
Yes, I do.
Now, in this case, in the case of the people of the state of Michigan versus Mr. Bashara, have you been taking all the search warrants to one judge in particular?
Yes, I have.
And which judge is that?
This is Judge Timothy Kenny.
How many search warrants, just approximately, have you taken to Judge Timothy Kenny?
I'm on a rough estimate, maybe about 70.
Okay. And back in October 2013, when you prepared this particular search warrant, did you follow your ordinary course of taking that to Judge Kenny?
Yes, I did.
And did Judge Kenny tell you to take it to someone else?
Yes, he did.
And did you do that?
Yes, I did.
Okay. And the other judge, was that Judge Michael Hathaway?
Yes, it was.
And that was at Judge Kenny's direction, correct?
Yes, that's his alternate.
Now, after Judge
You
Hathaway...
don't know that, do you? You just know that he said to take it to somewhere else. Is that correct?
Did Judge Kenny tell you something?
Yes, he's told me before to take it to his alternate, which is Judge Michael Hathaway.
And did you do that?
Yes, I did.
And did Judge Hathaway review the affidavit?
Yes, he did.
And did Judge Hathaway, in your presence, sign the search
Can
warrant?
attorneys approach?
Well, it's always just me and Mr. Moran.
Yeah, just you know. Oh, no, yeah, okay.
I have Lisa too, she's my lawyer.
You may need one after this is over. Come on.
Any more?
Come on down. Okay, maybe something was hit. Yeah, okay, if you're good, go ahead. All right, go ahead, I'm sorry. Maybe I just don't, I'm sorry. Okay, thanks. Go ahead, sir.
So after you went to Judge Hathaway, you indicate he reviewed the affidavit?
Yes, he did.
And did he swear you in and authorize the issuance of that search warrant?
Yes, he did.
Now, that search warrant affidavit was sealed, is that correct?
Yes, it is.
And that was also pursuant to your practice?
Yes.
Okay. And the tabulation was also to be sealed, correct?
Yes, it is.
Now, when you went to execute the search warrant at Mr. Valente's home, did you also have a subpoena?
Yes, I did.
And were you directed to have a subpoena by attorneys from the Wayne County Prosecutor's Office?
Yes.
And when you directed to first attempt to serve the subpoena on Mr. Valente?
Yes.
Okay. And did you go to the home?
Yes.
And did you attempt to serve the subpoena?
Yes, I did.
And what happened when you attempted to serve the subpoena?
When I handed the subpoena to Attorney Dean Valente, he said that he reviewed it and he said he could not comply with it because it would be considered attorney-client privilege.
Okay. And then after he refused the subpoena, did you then present him with the search warrant?
Yes, I did.
Okay. And were you present during the execution of that search warrant?
Yes, I was.
Now, at someone's direction from the Wayne County Prosecutor's Office, was any and all items taken from Mr. Valente's home, were they sealed?
Yes.
And did you follow directions from an assistant prosecutor to do that?
Yes.
And were those documents sealed into a box?
Yes.
And in fact, several boxes, correct?
Yes.
And they weren't even inventoried, were they?
No.
Okay, they were sealed.
Sealed. Yeah.
And why were you directed to seal that material?
Because we weren't sure. We wanted to make sure that nothing would violate the attorney-client privilege that we had taken it from the house.
Okay. And once the material was sealed, where was it taken?
To the Grosse Pointe Park Police Department.
And was it placed on evidence but sealed?
Yes.
And is it your testimony, Detective White, that no one examined that evidence to your knowledge?
None.
After it was sealed? Okay.
Yes.
I have nothing else.
Detective White, you've been in law enforcement for how many years?
26.
And you were with the Wayne County prosecutor, with the Wayne County Sheriff's Department,
Yes.
and you retired?
No, I'm still currently active.
Okay, you're on leave, you're assigned to the Wayne County Prosecutor's Office, is that
Yes.
correct?
Yes.
But you're still employed by the Wayne County Sheriff's Department, is that correct?
No, I am a Wayne County Prosecutor's Office employee.
Okay.
It's
I'll move
a
on.
difficult way to explain it.
There's no need to.
But you're not moonlighting, are you?
No, nothing like that, no. No.
Now, you've been actively involved as an investigator for the prosecutor's office on the Bashara case
Yes,
for some period of time?
yes.
For how long?
Basically since its inception.
Okay. And when was that?
Probably February of 12.
Okay. Now, you testified that on October 29th, is it October 29th, 2013, is that when the search warrant was signed? Yeah.
I believe that the search warrant was signed on the 28th and executed on the 29th.
All right.
And that's October.
Yes, ma'am.
All right, so-
October of 2013.
Okay, so I'm going to digress for a little while. So the search warrant was presented to a magistrate judge on October 28th, is that correct?
Yes,
And was executed the following day.
yes,
Okay. You also mentioned, you testified, that there had been a subpoena for documents and records of Mr. Valente.
I'm sorry, yes.
Okay, when was that subpoena prepared?
I can't remember when exactly it was prepared offhand.
Would you agree with me that it was prepared several weeks before the search warrant was requested?
I'd have to see the document.
Do you have it available?
Me? No,
Yeah.
I do not.
Well,
We gotta take, is there some way that we can get this document?
can we stipulate? We could-
We don't have it this round.
Judge, just real quick, is that was a key issue, well, last time we were here, was the fact that there was a subpoena and search
Wait a
warrant.
minute, just wait. Is there a possibility if we take a recess, you could go get a copy?
I'm not even sure if I still have a copy of that. I'd have to go look in my records.
You don't have any documentation. Is there some way that we can get that from a typist? Excuse me,
I know where it is.
where's,
When they executed the search warrant, they served Mr. Valente with the subpoena, and they took the subpoena back and they put it in the other documents that they seized from his house. So that's where we saw it.
so you don't have a copy, you don't believe you made a copy of the subpoena?
I don't think I did. I think I had one copy.
One copy?
I believe so. If I'm trying to remember from recollection what exactly, if I had one or two, or
It's incredible, because if you serve a subpoena, you give the subpoena to the individual, so you would have to keep, you give a copy to the person, so you have to have the original to have it filed or some type of.
Well, we
This
understand that.
is interesting, but I object. This is not relevant because the search warrant was executed. The subpoena was not authorized. Was not honored.
All right.
So it's irrelevant.
It's not irrelevant, because in fact, what we were saying, and the reason for our motion for return of the property was that they were armed with the subpoena, that they could have presented to him, and normally, like what is done, you give someone an opportunity to present, to produce the documents, especially when they're so sensitive as an attorney's files with work product and confidential materials. So what happened? So what we're saying happened is that they prepared a subpoena 2 weeks
Well, let me
prior
ask-
to the search warrant.
Would you stipulate to that?
No, I don't have a copy of the search.
They do have
subpoena.
it. It's in their office.
Judge, I think it's in where Mr. White, or Mr. Sharp said, it's probably in the box with
Is
the
the box
materials.
present in the building?
It's on lockdown, but we don't have access to it. It's sealed.
No, I don't think that's a sealed document.
Well, I haven't gone through the
Is
Is there
materials.
some way that you can go back and check your office to see?
I could look, yeah.
But Judge, why is this relevant? Because Mr. Valente refused the subpoena. He refused to honor the
Well,
subpoena.
we don't know that that is the case.
It doesn't-
That's his testimony.
That's fine, but I'm saying it was never honored, and so as a result of his refusal, the search warrant was presented. He could have said, okay, I'll comply with the subpoena, then we'd be talking about a subpoena, but we're talking about a search warrant, a court order, because he refused to comply with it.
Well, that completely contradicts their argument, because if they had a subpoena that was prepared 2 weeks earlier,
And do you have any recollection when you first became aware that a subpoena had been prepared?
To give you an exact time, I could not.
I'm not asking you for exact time. I'm talking about whether it was a week or 2 weeks or how long before before October 29.
I couldn't give you an exact time.
Well, let me
no.
ask you
I'm
a
not
question. Wait a minute. When you had the search warrant, why didn't you just go out to Mr. Valente's home and serve him with the search warrant?
With the subpoena.
I'm sorry, with the subpoena first.
Because they wanted to,
They being, I'm sorry.
I'm sorry, when we was given the subpoena.
Who gave you the subpoena?
No, presumably an attorney.
Yes,
The prosecutor's
yes, yes.
Okay, but when they gave it to you, why didn't you just go serve the subpoena at that time, sir?
Because the concern was that the subpoena would not be complied with, so we wanted to have a search warrant to back up the subpoena. If the subpoena couldn't be complied, we could execute the search warrant right then and there. Because from what I believe is that we wanted the documents forthwith, from best of my recollection, and if we couldn't get the documents forthwith, then we would execute the search warrant.
Very good, go ahead. That's just a procedure. I'm not getting into the search warrant or I'm not getting to the affidavit or search warrant. Go ahead.
Was there a discussion before you execute the search warrant that in fact you were seeking certain sensitive documents that could have been considered work product or privileged information?
I don't think that was never discussed, no.
Did you know he was a lawyer?
Yes, I did.
Did you know that he was a lawyer for Mr. Bashara?
Yes.
Okay.
Yes.
And you prepared the affidavit, didn't you?
Yes, I did.
So you wrote in the affidavit what you were looking for.
I'm not getting into the affidavit.
Well, it only goes to his knowledge as to what they were
As to
looking
what
for.
he did, okay, I'll allow it for that.
I'm sorry, could you repeat the question again? I'm sorry.
You prepared the affidavit.
Yes, I did.
You were requesting the search warrant.
Wait a minute. Before we even go any further, is there a stipulation that the search warrant was, that the affidavit and the search warrant were valid?
No.
Okay, well, I'm not going into that.
Because, okay, and I'm not either, but I haven't, how could I can't stipulate to a document I haven't seen.
Does he have it? Do you have this?
They haven't given it to me. I've requested it numerous times, and I said I'd like to have it before today's proceeding.
Do you have it, sir?
Judge, it's sealed by court order. Even if we had it, we could not disclose it without violating a court order.
Well, move to unseal it at this time.
You can do that in front of the judge who issued the search warrant. I mean, we don't have the authority to turn up something over. It would be a violation of the court order. We would be in violation and subject to contempt charges.
Right, but they could have moved. They could have moved at any point in time to unseal it, and they're sitting back on that, and they're not doing so, knowing the trial is supposedly next
Don't worry
week.
about the trial.
Judge,
I got the trial.
the
I don't need you to worry about the trial.
The affidavit has nothing to do with the procedure of executing the search warrant.
Very good. Let's move on.
Right. So, you know you're looking for certain writings and papers, correct?
That's correct.
That were prepared by Mr. Bashara?
Yes.
Was there any discussions with you with the numerous prosecutors that you were working with, that there could be some questions and issues regarding the confidentiality, the work product, attorney-client privilege? Did you have any of those conversations?
But what does this have to do with the execution of the search warrant and his request for return of property? Nothing.
Sustained. Let's move on. So anyway, what happens when you go over there with the search warrant? How many officers go with you? Yeah.
Probably about 6 or 7.
Okay, and then you go, how are you directed? Or where are you directed?
Are you talking about what was the procedure when we got to the house?
Right.
Myself and the captain from Grosse Pointe Park knocked on the front door. When we got to the house, we didn't believe anybody was home at that time, so we knocked on the front door, didn't get an answer. We attempted to check the door, see if it was open. It was open. At that point, we were making entry into the house because we didn't believe there was anybody home to serve the search warrant, or serve the subpoena on, so we're going to serve the search warrant. And that's where we were met with by Mr. Valente.
Okay, go ahead.
So, what you're saying, are you standing by, is it your testimony today that there was only 6 or 7 officers in entirety present there at that time?
Yes.
Okay.
Okay, I'm not going to allow any further, us to go farther in it, because what you're requesting is to return to this property.
Yes.
Okay, so this is an answer. Go ahead.
Well, I thought the court wanted to have a hearing, and I'm trying to determine, why it's necessary, why it was necessary to seize his property, and why it's necessary to retain his property at this time.
All right, the issue of why it was seized is really up to the court. I mean, we just want to know the procedure, what was done.
Okay.
I'm not going into the validity of that affidavit. That's before another court.
Right,
I'm not
I'll go
going
back.
there.
I'll go
I
back.
just want to know the procedure.
Hey,
So anyway, you go out there, and so then you see Mr. Valenti. Once you see Mr. Valenti, he says, I'm not honoring the search warrant because it's some work product, the subpoena. So then you give him the search warrant?
Yes, ma'am.
And what do you take?
We took any paperwork that was listed with Mr. Bashara's name on it, files, writings.
And where'd you get this from?
It was from the office area and other parts of the house.
you see his newspaper articles?
I believe so.
You see his photographs?
Not sure exactly if we received seized the photographs or not.
Okay. Let me digress just real quickly. You went there, first of all, and primarily was to serve a subpoena?
Yes.
Okay. And you're aware of the fact that you can't enter someone's house to serve a subpoena?
Well, at that point, the subpoena wasn't going to be served. We were going to execute the search warrant.
So before you even came in contact with Mr. Valenti, when you entered the house, it was your intention to execute the search warrant?
Yeah, no, I object as irrelevant. This is not relevant to the term of the property.
Answer the question, then I'm not going to allow any more questions. All right.
When we didn't get any answer at the door, there was,
Sir, did you understand the question?
you asked
Rephrase
me.
it. Restate it. I'm sorry.
Okay, I'm sorry.
When you cross that line and enter his house, his
Right.
office,
Right.
you crossed the line from subpoena to search warrant, didn't
Right.
you?
Yes.
So when you went in there and had contact with Mr. Valenti, it wasn't, by crossing the line, it was no longer to give him the subpoena. You were executing the search warrant. You were searching his house.
That's wrong.
Okay, very good. Let's move on. So then you come, and so everything that had Mr. Bashara's name on it, you seized it.
Yes,
And
ma'am.
what you do when you say you seized it, you put it in boxes.
Put it in boxes.
Did you catalog? When you execute a search warrant, you're supposed to prepare a return, you're supposed to prepare a return, are you not?
Yes.
Okay, and that means that when you're at the location, you're required by statute to categorize and list everything that's taken from the person's house. Is that
The
correct?
tabulation is sealed. So there would be nothing left.
Okay. Was there a tabulation done at the house at that time?
No, it was not.
So you violated the statute also by not conducting the tabulation at the house when you were collecting the property.
The tabulation doesn't have to be done at the house. We just
That's
have
for the
to.
court to decide. Let's move on. Go ahead. But you didn't do it at the tabulation at the house. Is that correct?
No, ma'am.
How many boxes did you take?
I cannot remember offhand.
In excess of 5, 10?
It was probably, could be anywhere between 5 and 10.
Okay, very
Okay,
good.
I just go back for an inquiry
Yes,
that the
sir.
court wanted.
Yes, sir.
When you prepared the affidavit for the search warrant in Mr. Valenti's law office, did you have a discussion with any of the prosecutors as to what judge you should take that to?
No, I take everything. Are you talking about why did I go to Judge Kenny?
Yes.
I always take everything to Judge Kenny.
Okay. And prior to this date, the 28th,
Yes.
had you ever taken any other search warrants to present them to Judge Hathaway?
We have had prior ones, but that's when Judge Kenny wasn't available.
Okay.
And he instructed us in his stead to go to take him to Judge Michael Hathaway.
On this particular date, when Judge Kenny was not available, and you were aware of the fact that this was a search warrant for an attorney's home, did you contact anyone in the prosecutor's office as to the ultimate plan as to whether you should take the search warrant to Judge Hathaway or to someone else? You understand the question?
No, because I think you're getting it wrong.
Well, here, let me understand something. When you presented this search warrant and the affidavit to Judge Kenny,
Yes,
you were aware it was for an attorney's home.
yes.
You understand that, is this the first time in all your years that you executed a search warrant in an attorney's home?
Why is that relevant? I object.
Well, I'm allowed. Is it yes or no?
I believe it could be. I can't remember ever.
Okay, all right.
Okay, I'll move on.
Okay. The door.
Right, after you told him that you were searching the house.
No,
Okay,
that's when I gave him the subpoena.
okay. So your testimony now is that you gave him 5 minutes.
Somewhere around
So what
there.
did you talk about for those 5
That's
minutes?
not relevant.
All
Move
right,
on.
all right.
Okay, so then let's just get back to they're in there. They take everything with Mr. Bashir in their 5 boxes and you seal it up. Is that
Yes,
correct?
exactly.
And then what do you do with it?
Everything is transported to the Grosse Pointe Park Police Department.
Okay.
And when you say you took everything that had the name Bashara on, is that correct?
Absolutely.
You didn't take just these writings and diaries, or anything that had a picture of Mr. Bashara, a newspaper article of Mr. Bashara, anything with any property that were in legal files, and you did take legal files, correct?
We took everything that had his name on it,
Okay.
that we could find.
Okay. That wasn't moving. All right. You boxed everything up
Yes,
and took it to the Grosse Pointe PD?
yes.
Okay. When did you inventory this?
I did not inventory it.
Okay. But it was not inventoried at all at the house, is that correct?
No,
Okay. One further question. Did you write a report?
No.
So when you were a Wayne County Sheriff, you used to write reports, incident reports, when you would do an investigation and execute a search warrant, didn't you? Wouldn't you? Isn't that proper procedure?
No, it depends on what we're going to be doing. It will be a case-by-case basis on what we're going to do.
And this is a very important case, wasn't it?
It is.
Probably one of the, besides the plumbing case, it's probably the biggest case you ever
It's a
had.
very big case.
No,
yes.
sir. All right, go ahead.
All right. Well, we get, you never considered preparing a report after you executed the search warrant to document what happened that day and your interaction with Mr. Valente?
No.
Did anyone ever ask you to prepare a memo,
No.
a report?
No.
All right, so when you
Now,
test,
we're getting away from
Very
what
good.
he did. What did you box it up and you sealed it?
Yes,
You
ma'am.
transported it to the Grosse Pointe Police and then they transferred it to the prosecutor's office?
Yes.
Okay.
and you don't know what happened with the subpoena?
Not offhand, no.
All right, very good. Anything further?
No.
No. Step down.
Thank you, ma'am.
Procedurally, it's my understanding that once that information, the items were seized from Mr. Valente's home, then they were taken to the prosecutor's office?
Eventually, they ended up there, Your Honor. I can just, as an officer of the court, I can tell you that I had a conversation with Detective White and told him to seal everything, put it in the box and seal it, don't tabulate it, don't look at it, don't review it, put it on evidence in Grosse Pointe, and that way, if it becomes an issue in the future, which I knew it would be, then we could then have it preserved. And then
Now,
it's
where is it physically?
physically, it's in our office in our locked vault area.
Okay, very good. And it's my understanding that that Gene Stempian had been appointed as a master. Is that correct?
Yes, Your Honor.
Okay, verbally.
I don't know. I have not seen a written order from Judge Hathaway.
I don't know.
Okay, very good. Now, anything further that you wanted to place on this record?
No, I'm Catholic.
I do. All we want.
Excuse me? Okay, this is what I'm going to do. Two things. Number one, the court is going to order that the item seized pursuant, you're going to get a court, I'm going to have a furnish order to you. On October 29th, that were initially reviewed by the master, who is Third Circuit Court Gene Stempian. Because of the court, the amount of items that were seized and the familiarity that Judge Stempian has with this information, I am going to formally appoint her as the master to review those items, to make that, I want her to make her report made known to me. And then what I'm going to do is I'm going to do an in-camera inspection of anything that is a work product. And if so, at that point in time, then we will, based on that, I will have the attorneys that come back, and then we will ultimately release the property back to Mr. Valente. That is not an issue.
But we're missing the point, Judge, is that when we met in the prosecutor's office, we divided the material seized into separate boxes. The box that contained information that was possibly work product or privileged, that is the box. That is the box that was sealed, was actually sealed again and provided to the master. There's another box which just involved, and that's the box that we're seeking, and that's the box with just Mr. Valente's files.
Sir,
That
I plan to review everything to make a determination if in fact those things were just some personal items of Mr. Valente's. There's no reason that they should not be immediately given back to him. And the other items, there will be a determination made as to whether or not those items can be released. However, what I want to do at this point is we don't know what the master's, first of all, she is now formally appointed. I want to see her findings. Based upon her findings, I now feel that it's proper for me to have a conversation with her, and then I want to do an in-camera inspection. I understand what you said, that there was an agreement that everything was divided in boxes, and in one box it just had some personal issues. I plan to do this forthwith. I have the order prepared, and I'm going to give everybody a copy. That copy will be made available today or tomorrow.
And then I'm gonna contact Jean Stempien to find out if her findings have been made available so that we can get on this forthwith and get Mr. Valenti back his information.
But that information we're requesting is not something that Judge Stempien reviewed. That's a separate box. We're talking
What
about a
box
box
is
that we've
that?
already, it's a box of files, of legal files, that is separate from what Judge Stempien did.
Okay.
Those are files that we've reviewed. Those are real estate files and
Okay.
property files that have nothing to do with this case.
Okay,
And
and what
we
the
told,
court is going to is going to find is that any and all material that has nothing to do with this case will be turned over to Mr. Valenti within the next 15 days. And I have an order that will reflect the court's finding, as what I've indicated. Anything further?
Judge, just a housekeeping matter. Physically, the files are in our possession. Does the court in the order? I mean, they're locked up in our file room in the vault. Do you want us to? Is part of the order going to be to turn those over to the court for the in-camera inspection, or are you going to wait for the master's report?
From my, I don't know when that report is
Okay.
going to be due, but I think that the report may have been prepared. I don't know.
All right.
I'm going to find out. And let me indicate for the record, and thank you for that. 15 days from the court's receipt of the master's report, those items will be returned over to Mr. Valenti, which I anticipate is not going to take longer than this month. It will be done expeditiously. I promise you. As a matter of fact, this is what the court is going to do. I'm going to, today is what?
18th.
The 18th. The court is going to set the next hearing date, March 11th.
Judge, those files that we're talking about, had nothing to do with
Counsel,
the
I
master.
made my ruling and that's it. Thank you. All right, very good. You'll have a respective order regarding this by tomorrow. My secretary's out. Okay, very good. Thank you. Good seeing you. Good seeing you. Okay, let's get Mr. Bashara. Mr. Bob Bashara. Come on. All righty. Very good. Okay, back on the, excuse me, back on the record in the matter of the people of the state of Michigan versus Bob Bashara. Appears for the record.
Lisa Lindsay on behalf of the people of the state of Michigan.
Robert Moran, assistant prosecutor.
Mark Hindelang on behalf of the people. Mark Persida on behalf of Mr. Bashara.
Nancy Schellebring on behalf
Mr. Bashara, there's something you want to say to me, and what is that?
Your Honor, I've prepared a letter that I had hoped you would have gotten prior to today, but it's a page-and-a-half letter that the prosecution is reading. I'd like you to just take a minute and read it.
I don't know why I wasn't given the letter first.
Well, I
just gave it to us, Judge.
suggested that, Your Honor. I gave it to one of your deputies to bring
Well,
to
what
you.
the court had indicated for the record is there a deputy available to give me that documentation? You, no, as a, no. Okay, very good. Thank you. I'm in receipt of this letter. What I am going to do is, the court indicated previously that it was within my purview to appoint counsel for Mr. Bashara. At this time, based on the letter and the desire of Mr. Bashara, I am going to remove the defender's office. I'm going to appoint David Cripps and Gabby Silver to handle this particular matter. Although there is a request that they be able to join in, I just think at this point I'm gonna remove them. I am going to appoint another attorney. However, I am going to appoint the Mr. Bashara 2 attorneys, and that the next attorney will be forthcoming. But I am going to appoint David Cripps and Gabby. So I just believe that at this point in time, with the volume of information and his initial desire to have him to be appointed, that they will be here. I will have them back on March 11th. Yes, Ms. London?
Judge, just for the record, I discussed it with counsel and we reviewed the case law. And defendant must waive on his record any appellate issues because according to the case law
Of 180-day rule?
No. According to the case law dealing with the court's ability to remove attorneys, it says that the only way and the only reason why that a court can remove a defendant's counsel is for a finding of gross negligence. And that is the case law, and that's People versus Arquette, citing Harlan versus United States 387. And I can give the court, but they said these are the only reasons that the court can remove a person's appellate counsel. And specifically, Harlan says merely disagreeing with the conduct of the way an attorney is presenting the case or going about preparing the case is not sufficient. So if the court is in fact going to be removing counsel and giving new counsel, Mr. Bashara must waive on the record now any claim in the appellate arena that this is some type of error. If we can get that waiver,
Let me see the case law that says that.
I highlighted. If each case is highlighted.
Is there? Okay, this deals with, I guess, his first case, the Arquette, because I haven't had an opportunity to really review it, with the desire of the defendant to have his own retained attorney.
All of the cases that I've given the court more than one case, and there's a brief. If I can just put on the record.
I think that that's a little obviously different.
Well, can I just?
Okay, go ahead.
Okay. A court may remove a defendant's attorney on the basis of gross negligence, incompetence.
And that's Michigan versus Fisher.
People versus Arquette, that's, and I only have Northwest sites, although you have the actual cases up there that have the Michigan sites, and it's 507 Northwest 2nd, 824. According to the standard set forth in People versus Arquette, defendant's counsel may be removed if it's on the basis of gross negligence, incompetence, physical incapacity, physical incapacity or contumacious conduct. The court in Harlan, the case I just talked about, People versus Harlan versus United States, the trial court may not remove a defendant's counsel merely over a disagreement regarding the conduct of defense counsel. There's also People versus Johnson. It says the court may not arbitrarily or unjustifiably remove the attorney over objection of the defendant and defense counsel. To do so violates the defendant's Sixth Amendment right.
Okay, very good. But
can I finish making the record? The whole basis, and the court has said repeatedly, and the court has said on the record that the court was confident that counsel could do the case. The court indicated in the transcript of January 9th, page 9, lines 11 and 12, the court is familiar with Mr. Procida, and I know his skill level is above normal and above average, and I know he'll be able to do a good job with this. The last transcript we were here, the court indicated that Mr. Presida and Mr. Shell and Ms. Shell had stellar attorneys. Furthermore, the last time we were in court, Mr. Bashara himself indicated that he was satisfied with the defender's office.
Okay, now he's indicating that he no longer wants their representation. Is that correct? Yes or no?
Yes, ma'am.
Very good. I'm gonna remove a lot of them.
Okay, now what I'm asking though is for him to at this point waive on the record any.
Shh. Be quiet.
I'm asking him to waive on the record any appellate claim he has in this regard,
Okay.
because it is his choice to do this.
No, this is what I'm going to do. I'm going to ask him a series of questions under oath, and I'm satisfied with that. Raise your right hand. Do you solemnly swear affirm testimony about to give this man the truth, the whole truth, nothing but the truth, so help you God?
I do.
Mr. Bashara, you understand that you have the absolute right to have the defender's office to represent you. Is that correct?
Yes.
From your letter, you indicate to me that you initially wanted, and you did make this reference, that you wanted to have David Cripps and Gabi Silver, who they're a team married, to represent you. Is that correct?
Yes, ma'am.
And is my understanding at this time, is that your request?
Yes, it is.
Very good, then I'm gonna remove it.
Also, at this point, can we have him waive on the record any speedy trial claim?
Okay, very good. Now, let me explain that to you. As a result of me getting in a new set of attorneys, you understand, sir, that we're not going to be able to go to trial in March.
I do understand that. Yes,
Would you?
ma'am. You asked me a
No,
question.
I'm
I'm
just
sorry.
saying, I wish everyone would stop talking when I'm talking. This is important. I'm trying to make a record. If it's not back over here, it's over here, please. So do you understand that, sir?
Yes, I do.
Okay.
That we're not, I'm sorry, repeat the question, that we're not going to
Okay,
have.
right. We're not going to March.
Yes, ma'am.
There's no way.
I understand.
I have to get them up to speed. There haven't even been, formal motions that have been filed in this matter. The transcript has been received. Moreover, on March 11th, when the court comes back, not only am I going to formally move to put Mr. Cripps and Mrs. Silver on there, I am going to I've been given the right to have another attorney appointed, as well as to appoint or to have supplemental individuals brought on this case to assist the attorneys as far as copying, just doing handiwork. You understand? So that's what I'm gonna do. I'm gonna do that March 11th. Now, let me go back to this because this is important. It's my understanding that and I'm gonna make this real clear. It's nothing obviously personal with Mr. Presida and Ms. Schnell. Is that correct?
That's correct, absolutely.
And you wanted Mr. Cooper, who normally was the lead attorney. Is that correct?
I don't know who was the lead attorney, but the
he
three
was
of
on
them,
right.
yes.
But when he was removed from the case,
Yes.
did that make you feel that you were not satisfied with the representation that you were receiving?
It caused me great consternation, yes, ma'am.
It did. And so as a result, now there is a request. Do you understand? It's my understanding.
Your Honor, but if I might put an asterisk.
The court is going to make the following finding: defendant's waiver is knowing, voluntary, understand, intelligent, and made. Court's going to so accept it. See March 11th. Good luck to both of you.
Thank you.
Meet me on another matter.
Grab your
Is she still
Oh. No, she's gone for the day.
Good day. Thank you, sir.
You know what?